Hello and welcome to Rajya Sabha TV. You're watching Constitutionally Yours from the campus of Himachal Pradesh High Court. In this program, we attempt to demystify the provisions of the Constitution. Joining me in this endeavor is Justice Dharam Chaudhary, Judge of the Himachal Pradesh High Court, Mr. Butail, Speaker of the Himachal Pradesh Legislative Assembly, and Shri Professor Prem Kumar Dhumal, who is Leader of Opposition in the Legislative Assembly of Himachal Pradesh. Also in the audience, we have students from the Himachal Pradesh University Department of Law. Straight away getting into the issues. Sir, Article 124 of the Constitution, which is meant for the Supreme Court, and Article 216 deals with the High Court provisions in the state. As it appears in the Constitution, it says there shall be a Supreme Court of India consisting of a Chief Justice of India and until Parliament by law prescribes a larger number of not more than 7 other judges. Article 216 says every High Court shall consist of a Chief Justice and such other judges as the President may appoint. We've come a long way from when it was written, about 60 years back. Today, the Supreme Court has a strength of 31 judges in the Supreme Court, and the High Court has a total strength of 1,056, out of which, unfortunately, 470 vacancies exist as of now. Now, that's where the problem lies. The appointments have been enhanced, but the existing positions have not been filled up. The Chief Justice recently made a statement and said that India requires 70,000 judges, and we are far, far away from that target. What is the reason? Why have the judges not been able to be appointed? The reason is the conflict of, or the misunderstanding, or the difference of opinion between the executive and the legislature, which exists relating to the appointment of judges. So straight away I'll come to the question, sir.
Yes.
When the Constitution in its Constituent Assembly debates has made it clear that the executive has to have a role in appointment and that the appointment has to be done in consultation with the Chief Justice, where was consultation interpreted as concurrence and veto to the Chief Justice of the Supreme Court?
There is still control of executive in appointing the judges, because it is the President of India who appoints the judges. Now, the recommendation, it is the Honorable Chief Justice of India who recommends the name in consultation with the 4 senior-most judges of the Supreme Court. And then the recommendation is made to the Ministry of Law and Justice, Government of India. And then it is, the recommendation is examined by the government. From each and every angle. It is examined by the Government of India. Then it is thereafter the Law Ministry forward the matter to Prime Minister of India, and thereafter, after the recommendation of the Prime Minister of India, it is sent to President of India. So still there is a role. There is a role of executive. Who says that there is no role of executive? Number one. Number two, now when in this country, bureaucrats are appointing bureaucrats, Army General Commander, they are appointing army officers, doctors are appointing doctors, engineers are appointing engineers, educationists, they are appointing educationists. Then why not judges should appoint the judges? Where is the problem? There is no problem. In real sense, there is no problem.
Sir, the attempt by the judiciary is to completely negate the role of the executive or limit the role of the executive in appointments, and all this is in the name of autonomy, which is also justified, because in the Constituent Assembly debates, the biggest discussion that happened was how to keep the judiciary free from political interference, and that is the basis of the autonomy that the judiciary wants to today claim. Do you see that affecting the delivery of justice system today if the conflict between the judiciary and the executive remains?
Now there are two words, you see, concurrence and the consultation. You see, concurrence has not been given because there is a straight away a danger of some bias in the uh, appointment of judges. You see, when some appointment takes place, it may be uh, a personal opinion of the, but if the concurrence of and consultation of so many people who are concerned with this, when it's appointed, you see, finally, there's a channel, you see, from the president to the president, law ministry, and everything. So, I mean, the authenticity of that appointment is very much uh, appreciated in the interest of the justices. And our appointing the judges, it's a matter of giving justice to the people, you see. It's not simply a appointment of the judges. We have to administer the justice to the people in a right way, you see. And if we don't synchronize who is sitting on the decisions, who has been appointed as judge, you see, it will be difficult also
To
for
deliver
the people.
justice.
Yes, yes.
So, Professor Dhumal, you've had executive experience. You were the chief minister of the state, sir. What is the fine balance between keeping the judiciary away from political interference and also allowing it to maintain its autonomy? What is the fine balance?
Now you have hit the nail on the head. वास्तविक समस्या मैं मानता हूँ
जी,
इस बात की नहीं है कि जुडिशरी पूरी तरह से स्वतंत्र हो या राजनीतिक हस्तक्षेप उनके अपॉइंटमेंट में हो। मैं मानता हूँ लैक ऑफ कम्युनिकेशन, जो संवादहीनता है। हम बाकी सब मामलों में चर्चा करते हैं, सब चर्चाएं होती हैं, तो सरकार और जुडिशरी के बीच अगर चर्चा हो तो बहुत स्मूथ रिलेशंस रहते हैं। जुडिशरी भी सरकार की सीमाओं को जानते हुए काम करती है और सरकार को भी सुनिश्चित करना होगा कि जुडिशरी इंडिपेंडेंट रहे ताकि न्याय हो सके। एक इंडिपेंडेंट जुडिशरी का अर्थ ये है कि आम नागरिक को न्याय मिल सके, सस्ता न्याय मिल सके, तुरंत न्याय मिल सके। आपने चर्चा की 124 और 214 की, शायद 224 में सुप्रीम कोर्ट को पावर है। सुप्रीम कोर्ट का चीफ जस्टिस विद द अप्रूवल ऑफ द प्रेसिडेंट ऑफ इंडिया अगर चाहे, वैकेंसीज बहुत है, काम का बहुत बोझ बढ़ गया है, तो रिटायर्ड जजेस को, जो सुप्रीम कोर्ट के जज रहे हों, उनको अपॉइंट कर सकते हैं। वही सारी रिम्यूनरेशंस मिलेंगी जो जजेस को मिलती हैं, लेकिन वो जज नहीं कहलाएंगे अदरवाइज़ बाकी सेंस में। तो आज तक स्वतंत्र हुए 1947 में हम, आज तक सुप्रीम कोर्ट के किसी चीफ जस्टिस ने इस जो पावर मिली हुई है 224 में, उसका प्रयोग ही नहीं किया। अगर समस्या इतनी गंभीर है तो किया जा सकता था और उसके माध्यम से एक संकेत होता कार्यपालिका को भी, एग्जीक्यूटिव को भी, कि भाई अगर तुम नहीं करोगे तो इस तरह जजेस लगेंगे। तो मुझे लगता है एक तो संवादहीनता समाप्त होनी चाहिए। वास्तव में जुडिशरी हो, न्यायपालिका हो, कार्यपालिका हो, हम सबको मिलकर देश की सेवा करनी है। भारत को स्वतंत्र रखते हुए शक्तिशाली सार्वभौम बनाना है।
So, but the biggest impact has been the litigant, the persons who come to this court seeking justice. Pendencies are mounting and there are rampant claims by people who come to this court for justice saying that it is tariq pe tariq and we are not getting justice. It's delayed, it's denied. I'll toss over the floor to the students. The first question.
So why there is delay in the appointment of judges, as the law of the land is very clear by the Honorable Apex Court that NJAC is no more in our country, prevailing in our country. So why there is delay? There are 170 recommendations already pending before the central government.
I have already said that it is not the legislature which is to decide. Even in the Constituent Assembly, when it was discussed, it was made very clear. First, the proposal was let the process be discussed in the assembly or in the parliament. but it was said that it will make it a very political thing. So executive, it's for executive. The executive has to reply, not the legislature.
Morning all. My question is to the judiciary. Sir, in a case in 1982, the president was given primacy over the appointment of judges. Then in 1994, SCORA versus Union of India gave binding effect to the president to appoint judges. So why is it so? Why isn't it against the principles of natural justice, appointment of itself by
I
itself?
have already said that when I'm not, though, with due regard to our former Honorable Chief Minister, I don't agree that the judges, that the doctors are not appointing doctors and army officers are not arming officers and then like that. Because as in our Union Public Service Commission, who has governed it? It is being governed by the bureaucrats, chairman, members or like that. And then always there is an expert member. Suppose a doctor is appointed, then doctor from medical side there is an expert member in that commission. Suppose an engineer is appointed, then engineers are sitting there. So educationist, then educationist, they are sitting in the commission.
You want to say that why
So,
should the government appoint, why can't the judges be consulted
sir.
and
Yes,
judges
sir.
be appointed? You
When-
want to rebut that, sir?
I think Justice Chaudhary has confused the things. To be an expert member of a committee, selection committee, is one thing, and appointing authority is something else. It's not the if engineer is sitting in the committee.
Appointing authority here also it is the President of India.
Sir, let him have his say.
That's why I'm saying
Yes.
that as in the case of judges, it's the President of India. The player of dismissal and giving recruitment is also the governor of the state or the President of India. Nobody is objecting. Consultation should be there, and I have already supported that it should be expedited. As you have very rightly pointed out, the basic question is why the justice is being delayed? Why unnecessary litigation? Why cases are pending? Where reports have been submitted? When I was doing law, then we were taught one case in the course that a case was instituted in 1869 when Mahatma Gandhi was born, and decision was given in 1955. It's not today's problem. It has been
Since then.
happening for centuries. So basically my point is, that's why I've said that I'm not in conflict with anybody. I'm supporting the point, but I'm saying have conciliation, have consultation, discuss things, stop this gap, which is communication gap is between the judiciary and the government.
So you are saying that the communication gap needs to be attacked, and that is where the
Yes.
two minds must
So
talk.
that justice is done to the common man who
Common
comes to
man.
the courts.
So the purpose is to provide services
Yes.
and let the gap be reduced and services be provided. We'll be back with the Article 128, which allows the appointing authority to appoint ad hoc judges. Welcome back. You're watching Constitutionally Yours on Rajya Sabha TV from Himachal Pradesh High Court campus. We'll take up Article 128. 128 clearly reads, and let me read it out for you. It says, as it appears in the Constitution, the Chief Justice of India may at any time, with the previous consent of the President, request any person who has held the office of a judge of the Supreme Court or the judge of a High Court and is duly qualified to be appointed or to be given the position of an ad hoc judge. Now this has been there for a long time, but this provision has not been utilized or exploited to the full extent. So my question to you is, why isn't, when there's an existing framework, why isn't it being utilized?
So far as high courts are concerned, it has been used. Just in big high court, the big high court where like Allahabad, it has ad hoc judges are being appointed there. But so far as Supreme Court, you have rightly said that in the Supreme Court, आज तक ये जो है provision इसको अभी तक वहाँ पर ad hoc judges का भी appoint नहीं हुए. इसका रीजन ये हो सकता है because so far as you are talking about pendency, pendency huge areas like that. ऐसी सिचुएशन हो, मैं नहीं मानता इसको, क्योंकि पेंडेंसी अगर हम द केसेज अप टू 5 years ओल्ड केसेज, ये पेंडेंसी में नहीं आते, ये पेंडेंसी में नहीं आते। और ज़्यादा जो पेंडेंसी है, ज़्यादा पेंडेंसी नहीं केसेज की है। अब 5 years वी डोंट हैव मच नंबर ऑफ केसेज। तो जो नए केस इंस्टीट्यूट होते हैं, कोई केस आज फाइल हुआ तो इट टेक्स टाइम मैच्योर होने के लिए फॉर हियरिंग। It takes time, years together, because there are other parties to be summoned. Then their response.
There's a procedure.
Yeah, there is a procedure.
Everyone has to be invited, notice has to be given.
I don't agree that there is huge areas. No, it is not like that.
That's contrary to the public perception. Sir. There is huge areas.
No, it is there, but pendency up to 5 years, you can't term it as areas. It cannot be said areas. ये तो process हो रहे हैं cases as per the procedure prescribed.
Right.
It takes time. एक केस को हम हियरिंग के लिए जब राइप करते हैं तो it takes time, because other side has also to be summoned and then reply, and response, and then sometime evidence also, and witnesses also. There are so many hurdles. So up to 5 years there is no pendency. और जो pendency हमारे पास है आज तक वो up to 5 years है. Above that it is very, it is not much high. You can see the figures also. It is like that.
बुटाइल साहब, आप इस मामले पे सर का कहना है कि 1 से 5 साल का जो पेंडेंसी है उसको पेंडेंसी नहीं हम लोग मान सकते। वो इसलिए नहीं मान सकते क्योंकि वो जस्टिस इन प्रोसेस है। वो जो एक प्रक्रिया है कानून का, सारे लोगों को बुलाना, उनको इक्वल अपॉर्चुनिटी देना, उनकी बातें सुनना और तब आगे की कार्रवाई करना, उसमें 5 साल लग ही जाते हैं। क्या ये पब्लिक परसेप्शन में ये पेंडेंसी माना जाना चाहिए? नहीं। उसके अलावा एडहॉक के अपॉइंटमेंट पे क्यों नहीं इसको इस्तेमाल किया गया जब जुडिशरी के पास ये हथियार या असला मौजूद था?
I think the meaning of the potency in real sense, you see, it varies from person to person, you see. According to Justice Chaudhary, the potency is not much, you see. But as the figures show, in the books, you see, 31 million cases are pending in the courts, you see. And that may be due to various factors, you see, not due to judges. There are so many factors, you see, lawyers tend to take adjournments every time, and there are so complicated cases also that takes time in witnesses. Sometimes there are so many witnesses when they have to be called in someone is not appearing, so the date has to be changed. That causes delay. But at the same time, pendency is no doubt, you see, there is a more pendency which is unexpected, you see, as compared to the other countries, you see, in America and England and Australia. The pendency there is there's quick disposal of the cases. Here it takes time, you see. Why it takes time? Because we
Judicial
have
process
complicated.
takes time.
Yes.
प्रोफेसर साहब, आपने अपना मत एडहॉक अपॉइंटमेंट पे तो साफ रख दिया है, लेकिन जो सर ने पॉइंट किया कि कहीं ना कहीं कॉन्फ्लिक्ट इस बात का है, कोर्ट का मानना है और जजमेंट भी है कि भाई हम एडहॉक क्यों अपॉइंट करें जब हम रेगुलर कर सकते हैं, और जब रेगुलर में कॉन्फ्लिक्ट में फंसा हुआ है तो एडहॉक क्यों ना अपॉइंट किया जाए? तो मामला तो अटक गया। द डिलीवरी ऑफ जस्टिस इज द बिगेस्ट सफरर इन दिस। व्हाट डू यू हैव टू?
मैं मानता हूं कि 2 इश्यूज को कंफ्यूज किया जा रहा है
जी।
वैकेंसीज वेदर ऑन द बेसिस ऑफ पेंडेंसी और ऑन द बेसिस जो कॉन्स्टिट्यूंट असेंबली में डिस्कशन हुआ कि इतनी आबादी पर इतने जजेस होने चाहिए। वो उसमें भी कम थे, जब 7 थे तब भी कम थे इन कंपैरिजन टू यूएसए और यूके। 2 व्यूज़ हैं। एक व्यू है कि बहुत सारे पॉपुलेशन बढ़ गई है, और उसको भी देखें तो 4 गुना अगर आबादी बढ़ी है तो 7 से 31 हो गए, उस प्रपोर्शन में भी बढ़े हैं ज़्यादा अगर आबादी आधार है तो
अभी का अनुपात है सर, लॉ कमीशन ने जो दिया था 50 हर 1 मिलियन के लिए,
मैं
और अभी
उसी पे आ रहा हूँ, मैं उसी पे आ रहा हूँ कि एक पॉइंट जो गिनने का, वैकेंसी गिनने का है कि 10 मिलियन पर 50 जजेस होने चाहिए। दूसरा आता है कि इतने केसेस पेंडिंग है। ज़्यादातर जो चर्चा हो रही है वो आबादी के आधार पर जजेस की नहीं हो रही, चर्चा पेंडेंसी की हो रही है। इसलिए जस्टिस चौधरी ने जो बात कही कि जो नॉर्मल कोर्स में केस चला हुआ है उसमें जो जुडिशियल प्रोसेस लगना है, टाइम लगना है, वो तो लगेगा ही, टाइम कंज्यूमिंग। जो बहुत ज़्यादा पेंडिंग है, अब जुडिशरी भी जब फिगर देती है, एक नारीमन साहब ने राज्यसभा में ही एक प्रस्ताव लाया था जिसमें स्टैटिस्टिक्स मांगे थे, उसमें जुडिशियल अकाउंटेबिलिटी की बात भी आती है, वो भी सारी बातें हैं। तो बहुत सारी चीज़ें हैं, हमें ओपन माइंड के साथ इस पर चर्चा करनी होगी। इसको कन्फ्लिक्ट के तरफ लेने की आवश्यकता नहीं है। आबादी के आधार पर भी जजेस हों और ताकि पेंडेंसी भी ना हो, और इसके अनुसार जब हम करेंगे। और फिर जब मैं प्रारंभ से कह रहा हूँ कि सवाल ये नहीं है कि जुडिशरी सुप्रीम है या एग्जीक्यूटिव सुप्रीम है या लेजिस्लेचर सुप्रीम है, तीनों मिलकर इस लोकतंत्र को सुदृढ़ करते हैं और देश की जनता को सेवा करने के लिए तैयार रहते हैं। और उस बात के लिए हमें सुनिश्चित करना होगा कि अपने ईगोज़ पर नहीं, ना सरकार को ये अहम होना चाहिए कि हम ज़्यादा शक्तिशाली हैं, हम जो करेंगे वो होगा, ना जुडिशरी को, ना लेजिस्लेचर को, ना पार्लियामेंट को। तो सब मिलकर अगर करेंगे कि हम कर किसके लिए रहे हैं, इट इज़ फॉर द कॉमन मैन, साधारण नागरिक जो है उसकी सेवाएं मिलें, जिसमें न्यायिक सेवाएं भी और अन्य सेवाएं भी मिलनी चाहिए। उस दिशा में आगे बढ़ना चाहिए।
We'll toss over for the questions. Yeah.
Morning, sir. I'm Anirudh Sood. My question is to judiciary. Sir, pendency of cases may also be attributed to judiciary in granting adjournments for petty reasons when the Code of Civil Procedure only permits 3 adjournments to a party in a suit. Sir, your take on this?
Yes. Sometime unnecessarily adjournments are there. But now our courts are governed by procedure. There are rules also. We are monitoring the this work in judicial courts, subordinate courts. So now it is not like that. And in case adjournment is given, it is only in the principle of natural justice. Sometimes there are genuine problems, so a case is required to be adjourned also. So it is not that now frequent adjournments are being given or without application of mind or unnecessary.
Next question.
Good morning, sir. My name is Jyotirmay Bhatt, and my question is for the executive. Why don't we have competitive exam for the appointment of judges for the Honorable Supreme Court and the High Court, like we do in the lower judiciary?
Actually, I think that is out of place to say, because all judiciary members they can go through the examination. Whether they reach the Supreme Court or whether they reach the lower courts, the procedure is the same. You see, when some judges pass out the judicial examinations, they rise, you see, according to their work done in the courts, you see. And those people, we don't have to think that the judiciary which is working in the Supreme Court does not pass through the examination. They have to,
बस सवाल एकदम साफ था सर कि अगर सबॉर्डिनेट जुडिशरी, मैं चाहूँगा कि आप इस पे स्पष्ट करें अपना मत कि सबॉर्डिनेट जुडिशरी में जब कॉम्पिटिटिव एग्जाम्स हैं, एंट्रेंस हैं और उसी से आप जुडिशियल सर्विसेज में एंटर करते हैं, तो हायर जुडिशरी में ऐसा क्यों नहीं होना चाहिए?
Who is appointed in higher judiciary? A session judge who is rendering more than 15 years service as a session judge, and initially advocate also, and who is appointed as High Court judge from amongst the lawyers, a person having rendered 20, 25 to 30 years, sometimes 30 years also, active practice in the profession. So do you think that they are still required to undergo some written test or like that? They are not clerk or babu, they are constitutional. They are constitutional authority. Judges are being appointed under the Constitution of India. Why there should be a written test or like that for them? So when now if coming to Supreme Court of India, who is being appointed? The Chief Justices of the High Courts, who are senior Chief Justice. So do you think that they are supposed to undergo a written test or some interview or like that? So it is their experience, the life they spent in the profession that make them perfect to understand the law. They need not to undergo any written test or.
I will add to that, the constitution clearly sets out the qualification, okay, and that is the qualification that is adhered to for all appointments in the higher judiciary, and that can't be tampered. If you have to tamper that, you will have to go in for a constitutional amendment, and that is why it is mandatory and important for no competition or entrance test. लेकिन आप पर आखिरी मत इस मामले पर. Having said the facts as it is, sir, आपका मत क्या है?
मैं मानता हूं कि
Quickly,
प्रश्न बहुत ही वैलिड है. जो चौधरी साहब ने कहा वो भी ठीक है कि लोअर जुडिशरी में एग्जामिनेशन से आए, सेशन जज बने, कोई सेशन जज से प्रमोट होता है इन द प्रोसेस, उसमें किसी को ऑब्जेक्शन नहीं है. जो मुझे लगता है जो प्रश्न किया गया है वो बहुत इंटेलिजेंटली किया गया है कि हाई कोर्ट में कितने वकील हैं, 10 साल, 20 साल, 25 साल, 30 साल की सर्विस वाले. यू ले कंडीशन दैट मिनिमम सर्विंग स्टैंडिंग काउंसिल फॉर 20 ईयर्स, वो टेस्ट में अपीयर होंगे. दो अलग अलग चीज़ें हैं. एक जुडिशरी से जो लोग आते हैं, जो सेशन जज की प्रोसेस है, वो तो प्रोसेस में हुए हैं, उनकी तो प्रमोशन जैसे बाकी प्रोफेशंस में होती है, इनकी प्रमोशन वही प्रमोशन है और मेरिट और बहुत सारों में से एक दो होते हैं. लेकिन जो बार में से लिए जाते हैं, दे शुड अपीयर इन एग्जामिनेशन और उसमें क्वालिफाई करें, उसका हाई कोर्ट में आए. सुप्रीम कोर्ट में नोबडी सेइंग कि सुप्रीम कोर्ट के जज का टेस्ट कराओ.
ठीक है सर. That's all we have time for in this segment. We'll be back with a new episode and a new show. Keep watching Rajya Sabha TV.